also an appointee. Yes.
Good to see you. How are you?
Oh,
Very well.
you're just arriving.
I'm just arriving now.
From the airport.
Yeah,
Oh, okay.
How are you? Yes, I remember. Yes, thank you. Hello, how are you? Very well. Very well.
Please.
No, thank you very much, CJ. I just want to make a follow-up on the questions the CJ asked. Maybe put differently. Judge, when are you retiring?
I'm told, I believe 1 June, should be 1 June 2024. A year and a bit, that's all.
1 June 2024.
Correct.
Now, you saying you are told. I want you to tell me, because you should be knowing yourself, when are you retiring?
I asked, sorry, Commissioner Malema, I had asked about a month and a bit ago, what is my actual retirement date? I am waiting for a response. I have not received it. The calculation is that my appointment, my letter of appointment came through on 26 August 2009. I know this because it was 2 days before my birthday. That's not because I have a great recall. Just happened to be that. My acting appointment, I had acted from 1 June, and as I understood it, as long as you act continually until your appointment, that is taken as the period. So that's why I believe 1 June, but there may be considerations that may or may not advance it. But I believe 1 June is on paper the appropriate date. There were earlier acting stints. I don't know if they're taking into account. I'd understood it's your permanent, continual acting period. So that's why, my apologies. That's why I can't be definite. What I can definitely say is it is no later than 1 June 2024.
I know it's our responsibility to decide to appoint you or not to appoint you. I mean, to recommend to the president to appoint you or not to appoint you. But do you think it's fair for this body to recommend to the president to appoint a person who's going to serve for less than a year in a court where we're actually struggling even to get people? If we appoint you and you go on retirement, it's almost going back to square one. So, in all fairness, and we are going, if we recommend you, we are going to recommend you now is April. We don't know when the president is going to appoint you. He takes his own time. He might appoint you in June, after June. He just appointed now the SABC board. It took forever for him to appoint that board. So it might take whatever period for him to appoint you. And that becomes less than a year into retirement. Really, do you think it is fair for not that you are appointing, but in helping this commission to come up with a good decision? Because after we take a decision of appointing, we'll get subjected to scrutiny. We get criticized, we get applauded and all of that. Do you think it's the right thing to do at this stage?
Fair enough. Thank you for the question. I see fairness slightly differently. If I was competing, there are 5 vacancies. If there were 5 candidates standing, I would not have applied, because I would have taken a position where somebody else could have gained that experience in long term. So I see fairness from that perspective. There are 2 candidates and there are 5 vacancies.
But what do you do to the fiscus? I mean, you are going to get some increase for a position that you almost served for less than a year. Sorry. And then you go for the rest of your life with that package. What do you say to the fiscus?
May I assist?
Yes.
The starting point is that there is no extra remuneration. So if that was perception by anyone who's not a judge, then if I could assist there, and I'm sure the judge presidents will confirm that, there is no extra remuneration. There is only extra work.
Okay.
Nothing more.
Now the last one, CJ, through your intelligence, the complaint, I know you don't know the merits of the complaint and all of that, and the same happens to all of us, that this complaint is here. We can't do anything about it. We can't say it is a strong case or serious allegations or anything of that sort. And I also don't know, because when they say there is a complaint, in the absence of anything before us, we then Google you, then there will be this tax issue, or maybe we don't know what
Sorry,
the issue.
what issue? My apologies.
No, I'm saying I'm not saying there's an issue on you. I'm saying if I were to Google you, and then they say there is a tax issue about you, I didn't Google you, or there is sexual harassment against you, or there's GBV against you. I don't know what the complaint is, but the complaint is firmly there. It's there. It's undisputed. The JCC, they've received the complaint, and the problem is that on our side, the matter is not being resolved, right? And we also don't know what the issues. Will it be fair for us to appoint you without knowing even the merits of the complaint? Because it is undisputed that there is a complaint. It is undisputed. And only after we appoint you, the details, because remember, that's why we said this matter, if it can be resolved outside, let it be resolved, because we didn't want to raise this out of respect in the presence of the media. But once they hear now that there is a complaint against you, then they go and dig up on the complaint, and boom, here we have appointed a person who's accused of serious violations. Will it be fair for this body to appoint you with this complaint that it is before us? Or should we wait and say, let's have the matter resolved, and then we can look into a candidature, perhaps, if it's possible? Thanks, CJ.
Thank you. The OCJ had 2 years to find this. I wrote. It's there. It's on the application, and the correspondence is attached at the end. I glanced at it. The only complaint, sorry, I can't say only complaint. The complaint is regarding a delay in a judgment, delivering of a judgment. That's all. It's got nothing to do with my behavior. It's got nothing to do with anything else. So, I believe my record is good in delivering of judgments. Again, I'd like to know what year that was, but I don't think it's current. And I believe that the profession as a whole, through their input, considers me to be courteous, considers me to be hardworking, diligent, applying. So it appears to be a matter concerning a long outstanding judgment at that time. But again, perhaps the Chief Justice can assist us to the year when the complaint was lodged.
Won't be part of it. CJ asked a question that what will be the difference acting now till your retirement and being appointed permanent? And I want to confirm what was your actual response to that question.
Fairness. Fairness. A person who, right from the beginning, had been identified while at the bar as having the capability of being in that court, not being given that opportunity right through my career. And eventually, through Judge Victor, 2 years ago, I think, when she was acting, and then Judge Valley when he was acting, there were no cases that came through for me at that time. So I've been waiting, and I've been sitting, and I've been waiting. It's your call. I'm not going to go with that further. It's a matter of fairness, as you perceive that fairness, as to whether there should be some form of recognition to being in that court or whether it's going to be an acting. I'm not making that call.
Thanks. Thank you, CJ.
Thank you, Commissioner Nyambi. Commissioner Baloyi? Sorry? Follow up? Okay. Commissioner Malema?
Thank you. No, let me understand this. That you have been identified from the bar and then this has not been happening and all of that, then you say fairness. Do you think you are entitled to this
No.
position?
No.
Because
No,
that
it's-
explanation comes across as saying, I'm entitled to this
No.
position.
Not at all. It's
Yeah.
something for you to consider. I'm just raising it. I'm not saying one way or the other.
Okay,
Thank you.
thank you.
Thank you. Another follow-up? Okay.
It's a quick one, CJ. Have you applied for this position before?
Yes,
Which year was it?
I think 2 years ago.
The same position of this?
I believe so,
applied for?
yes.
Okay, I missed that point. Thanks.
Thank you. Thank you. Commissioner Baloyi first. Can we accept that after they'd gone on your suggestion to do the inspection, they never came both parties to you and said, we have resolved the matter? You heard through some source that they'd resolved it.
Correct.
But that's not acceptable.
Okay.
You can't have parties before you who have a dispute, and they bring the dispute as an urgent dispute. You're supposed to resolve it. You hear argument, they go away, and you hear from somebody that the matter was resolved, and as a judge who was dealing with the matter, you never do anything to get the parties back to confirm to you that the matter was resolved.
That if I'm wrong, well, I'm wrong, but nobody until this complaint has ever asked me, where's the judgment or anything like that, neither party. So my assumption was that it had been sorted out.
Okay, you can see I've been battling to try and finalize, but Commissioner Malema
Yes, sure.
and the Prof.
Judge, which procedure is that one that after arguments and everything else, instead of issuing for judgment, someone must come and tell you to issue a judgment? Which procedure are you referring to?
No, I'm not referring to any procedure, but if a party or something slips by, then you will get some notification saying, we're awaiting a judgment, nothing has happened. You said you were reserving, we haven't heard it. Nothing like that happened.
No. You owe us justice. We came before you, we argued, and you know it's the practice of the practitioners respecting judges. You can't be saying to the judge, when are you delivering? Because there's no such a procedure anyway. You can't refer me to any procedure. In the absence of that, are you saying for as long as there's no one who says where's the judgment, you will never issue a judgment?
No, that's not what I'm saying. What I'm saying is that I understood that through when the argument proceeded, because clearly there was argument after the inspection, I identified what was really there, what was at stake, and what was at stake had been resolved. Because through argument, it was accepted that these people were in fact there, this group, and another group, I can't remember, 3 or 4, were not there. That was it.
And you hear from someone that we're not even told about, that the matter has been resolved, meaning that you heard it from a gossip.
No,
Because the
no.
only procedural
My
way,
apologies.
if it's not gossip, even if it's written in the papers, you can't even cite that as a judge. Whereas an unidentifiable body, the only procedure is that they must come before you and say we have resolved the matter. They've never come before you, and in the absence of them coming before you, what do you do as a judge? Because there are a lot of young practitioners who are listening here. They are learning through this process. If the parties before you don't come to you to say we have resolved the matter, what do you do as a judge? Do you go and hear things through a grapevine? Do you go and read about them in the papers? What do you do for as long as the two because you are a court as you sit there, as long as the court has not been told by the parties interested that they've not resolved the matter, what is the procedure?
That is why I was hoping to get that recording, because it was in that
Judge
process
Spear,
the various
Judge Spear,
council.
I'm going to interrupt you, I'm sorry. The question is simple. What do you do in this situation? What procedure do you follow? The answer should be, this is the procedure. If you know it, if you don't know it, I don't know what procedure is applicable.
No, thank you. But it was prefaced on the basis that it's gossip. It wasn't gossip. It was the parties themselves during that hearing.
No, but Commissioner Malema is talking about after the inspection. He says they didn't come back to you, both parties, to say we have resolved the matter. And he's asking, where that has not happened, what procedure do you follow as a judge?
But before he answered, Chief Justice, you said to him, you heard from someone.
Yes.
And he
yes,
confirmed that he heard
yes,
from someone.
yes.
So he can't now say he heard from the parties. He said he heard from someone, and then that the parties have resolved the matter. I'm saying you cannot hear from someone or the paper other than the parties which appeared before you. In a situation where the two parties say, where the two parties never said to you in court that we have resolved this matter, even if you hear it outside, as long as these two have not come before you, what is the way forward?
Okay. All right. The facts of this was that there was an inspection. I wasn't sure when we started this discussion whether the argument was before and after the inspection or just before the inspection. The Commissioner pointed out that the complaint indicated that there was argument afterwards, so I accepted that. So trying to recall what happened. They have their inspection, they come back. One of the council adopts a high-handed attitude, effectively, regarding, yes, but we've always had this position. I then flesh it out between them, and the outcome is there's an acceptance that those identified at that inspection who had a structure there could not have been demolished, because the city's case was that they never demolished any structure that was there. The outcome of the inspection showed that there had been a demolition. Those people, the occupants, had been then identified. There were others, 3 or 4, where weren't. During that argument, it was accepted that those, because that was the city's case. If you had a structure, we couldn't have demolished it. We couldn't. And it's clear because that's the law. So it was from the parties themselves during the argument where that arose. So it is hearing when that argument took place, because I believe there was argument before and after having been told what that complaint is. It wasn't just before. There was a sequence of argument, yes.
But Judge Spill, if you now say that this is what was said during the argument that took place after the inspection, that there was an acceptance by one of the sides of certain proposition, if they didn't tell you at that hearing that the matter was resolved, on what basis did you not give an order or decision if there was no settlement agreement? Because it seems to me from what you are saying that earlier on you suggested that they should do an inspection, which they went and did. Then they came back and presented argument before you. During the argument, one of the parties accepted a certain proposition from the other side. But they didn't say to you, we have resolved the matter. And if they didn't say we have resolved the matter, on what basis did you not give an order or judgment then?
Chief Justice, I'm going back a bit, but my recollection, and it may be faulty, but that is my recollection, is that in engaging, it was accepted by the parties that those who had been demolished and they were identified, they could, the application was to stop an eviction or to allow them to go back or whatever. And I was comfortable that that had taken place. So I accept that I should have made a note, but I'd understood that it had been resolved, and the fact that nobody came back indicates to me that it had been sorted out and my understanding was correct.
But come back from where? Because the inspection had happened before
Yes.
the second time of argument. So they were to come back from doing what? The second time when they came back to argue, there had been an inspection. They argued.
There was a pig-headed,
There was some-
sorry, there was, I mustn't use that term. There was an attitude adopted by certain counsel that did not make sense, and I then fleshed it out, and then it was accepted.
But at the end of that session, did they say we have resolved the matter?
No, I'd understood that they had. They did not say so expressly. I'd understood that they had
They had-
identified and had worked out through the problem and through my engagement with them.
So they had an argument before you for you to decide the matter. They left without saying they have resolved the matter, and they did not say you don't have to make an order. They didn't say you don't have to give a judgment, but you decided not to give a judgment
Because they,
during argument, some proposition was accepted.
yes, they had accepted that this was the rational way, that you can identify who the people were, and that was it.
Okay, I think.
CJ.
Oh, okay. I'm sorry.
Yeah. CJ, I was just, you took from me when I was doing
You want a follow-up?
that follow-up, yeah.
Okay.
So now, we are now agreeing that
Sorry.
what the CJ was saying to you, which you agreed to, that you heard it from someone, it doesn't exist. It's not true. It's not correct. You didn't hear from someone that there was a settlement.
No, it was during the course of the arguing and putting positions or putting my concerns or putting my understanding to the parties.
So now I'm saying you are leaving that one, that argument that we were saying you heard from someone that they've resolved.
I don't believe I ever said that.
You said that the CJ said to you, you heard it from someone. And you said, I heard it from someone that the parties have resolved this matter. We are leaving that one.
No, I don't recall saying it. I don't believe I said it. If I did, it was always incorrect if I did say it. But my recollection is that it was after the inspection, but it was always the parties themselves who were before me. And I certainly didn't hear from anyone other than, or make any assumptions other than from what was put to me and what was argued before me and their responses, but it was only the council involved.
Yeah,
So
but-
there's no misunderstanding on that. There was no third party.
So let's leave that one. Even on this one, the parties have never said to you, we have resolved this matter. They've never said that.
Not expressly. I understood that they had.
Eh?
Not
Well,
expressly, no. Not
I
expressly.
might not understand those things of expressly, and I'm not a lawyer, I'm a layman. I want to live here and go and explain properly.
Yeah.
No one ever said to you, we have resolved this matter of the parties.
Sorry, can I just try and recall? I may have put, then, is there any issue where A, B, and C are accepted, D, E, and F are accepted? And that's it. Yeah, my difficulty is that I've tried to get correspondence that preceded this, because there was correspondence that preceded this, but I can't.
No, Judge.
If I may, sorry, my apologies. I don't mean to be disrespectful.
No, I hear you, but I'm saying to you, in your own ways, There's nothing wrong with accepting that, the version you have put to us. I'm trying to put it in a layman's perspective. That which you are doing now of trying to say, you have said this, and then you have said that, you all do that all the time. And then Mugai Tobe and them will say, no, the other party has conceded, the other party has. Conceding and not conceding does not mean you can't deliver judgment, or you conclude that now the other party, because it conceded, it means now there is an agreement. And then there must not be a judgment. You know that. That is not how the procedure is followed. All I'm saying is, as they were busy conceding to you, as you put them to this side and put to this side, they were conceding to you. None of them, at the end of those concessions, none has ever said to you, we have now resolved this matter through your wonderful intervention.
No.
No
That's
one
correct.
said that.
That's
Yes.
quite correct.
Thank you.
The Judge President and Commissioner Nyokesi drew me to what I'm going to ask you on. You were asked a question in relation to the quality of judges and the judgments and the criticisms. And you repeatedly said that there are no criticisms that you are aware of, and correctly so, because we have not been furnished with any. And Commissioner Nyokesi also asked about the quality, and you also said you yourself are not aware of the challenges in your judgments. And then that drew me to the judgments of yours that I know I've read before. The first one is the one where you dealt with Matrimonial Property Act, and you dealt with issues of forfeiture and all those kind of things. But for the purpose of time, I want to go to another one that you wrote. This one you wrote, and that judgment was riddled with difficulties, right? Which I'm not really sure why the independent bodies were not able to pick up on those. But the one that I want to debate with you on is the one that you wrote in insolvency law. The body corporate of Heiselhurst versus Ramachia. It was delivered on the 27th of October 2017. I'm not sure if you remember that judgment. It dealt with, from what I can gather when I read the fact, it was compulsory sequestration. But when I read the judgment, it seems like you are confusing compulsory sequestration with voluntary surrender. And I'm going to point out something, and I want your comment on it. The difficulty that I have with this judgment is, and I'm not sure, it's not part of the PEG, unfortunately. I don't think it's part of the PEG.
Of the bundle?
Yes. In paragraph 9 of that judgment, but do you remember that judgment?
It's
because I want to be fair on you, but the thing is, I'm asking this based on the criticism that you raised.
if it's a 27 judgment, it's
2017.
Yeah, 2017. It's some time ago. I've had a couple of insolvency matters which I heard. So no, I don't recall.
But can I just point out?
Yes, you can.
The issues with this judgment in response to your response in relation to the quality of your judgment?
Yes, please.
In paragraph 9 of that, in paragraph 9 of this judgment, what you first do, you speak about the acts of insolvency, and you list about 5 of them. And when you start speaking about acts of insolvency, you give an impression that you are dealing with compulsory sequestration. In other words, what you are dealing with here is compulsory sequestration. And once you have outlined these, in the following paragraphs, you don't even deal with any of these acts of insolvency and what or which one of them is actually applicable in this case. And there is no reasoning in relation to the requirements of compulsory sequestration and as to why the person who is being sequestrated in this particular matter meets those requirements. And that is the first flaw that I found in this judgment. But apart from that, you confuse issues. In paragraph 21 of that judgment, you say something that is quite surprising. You speak about somebody making a notice to surrender their estate. And if you start saying somebody surrendering their estate, you moved away completely from compulsory sequestration.
Yeah.
You are now dealing with voluntary surrender. And that is the second issue that I have with this judgment. That shows, one, confusion in relation to the area of law. But secondly, lack of attention in relation to the research that is needed to actually get into the reasoning and the order that you're going to give. But the third fundamental challenge with this judgment, is the language that is used. In paragraph, you can just bear with me just for a second. In paragraph, I think 20 of the judgment, the language, the sentence construction that is used there, and when you read the entire judgment, and I mean it's unfair because you don't have that judgment, so you can see. But I just want to say that this judgment and the judgment that I referred to, it has similar sort of things that come out of them, where you rely on the law, not the law in terms of cases, but the law in terms of the statute itself, but your interpretation of the statute and your reasoning in relation to the statute leaves much to be desired. So I'm not sure whether it's accurate to say that the quality of your work generally it is satisfactory. I think there are points of weaknesses, and it's quite disappointing that some of the bodies have not highlighted it, and which raises a concern that perhaps maybe criticism seems to be restricted to certain people and not other people, and that for me is a concern. I'm not sure. What is your response to that?
Firstly, Commissioner...
No, DCJ.
Commissioner Malema?
I think in all fairness, that question is not in keeping with what we have adopted. Because it's not only the law bodies that have got a right to raise issues with the candidate before he sits here. We all do. If we look at the law bodies report and the issues we have, which the law bodies have not raised, we all have a right to raise those issues and send them to the candidate. And that hasn't been done. Yeah. And it's not me, it is through the admission of the commissioner that hasn't been done. And it's unfair to the candidate and to all of us, because even in the deliberations, that point cannot be referred to, since it has not been canvassed.
Thank you, Commissioner Malema.
No, before that, I take a point, but the thing is, I'm raising an issue based on a judgment which is a public document, which, of course, all of us will have access to, and we did that even yesterday, where somebody said the Supreme Court of Appeal confirmed me, and we all went to try to see whether indeed the Supreme Court of Appeal has actually done that. So the question that I'm raising is in relation to the judgment that the candidate actually authored. So it's not about the bodies or any other person criticizing. So it's my criticism to the candidate. So it's not really about anyone else. It's my criticism as the commissioner to the candidate.
Thank you. I hear you, Prof. But look, the judgment you say was written in 2017, and he has written dozens of other judgments since. So it may actually, I'm trying to put myself in his position, and I'm thinking, out of all the judgments I've written, if I were asked on a judgment I'd written 5-6 years ago,
I accept that.
It might be difficult, but the Advocate Olan Muta looks ready to answer. I don't know what he was going to say. Let's hear from him. If you feel that the question is unfair, you will say.
Before that, DCJ, let me just say this. I understand that. I said the question was based on the assumption, or the saying that there's never been a critique in my judgment. Then he went further and said, I am not aware of any challenges in my judgment. So I was asking on basis of the second leg, I am not aware. So I was raising that on that aspect.
And I just ask for clarity if this judgment was appealed against?
No, it wasn't.
It wasn't. All right.
If I may, Deputy Chief Justice, respond to that, and I would like to thank Commissioner Malema for that. Yeah, it is an ambush question, and I cannot respond to that because I don't have it before me. I've never said that I never made a mistake in any judgments. I said, in overall, I am not aware of criticism. And if this is a valid criticism, I would have expected, and in all fairness to all candidates, not only for me, but all the candidates who come here, is that you have in advance that criticism circulated to you so that you can be prepared. That is as far as I would go. I cannot comment on that. But a last thing is, if it was 2017, yes, I would agree in general that the quality of my writing of 2015, 2016, 17 is not as good as it is today because there is an improvement.
Commissioner Malema?
No, thank you very much. SC, I never heard you saying that your judgments, both in language and writing, are A+.
No, I didn't say A+. I said I don't have serious comments, criticism.
Yes, I heard you saying from the law bodies, and that question came from the JP.
Yes.
There hasn't been serious criticisms
Yes.
from that end. And that doesn't mean there won't be typos and all of that, because you just told us that English is not your first language.
That's correct.
Thank you.
Thank you, Commissioner Malema. Any further questions, colleagues? All right. Well,
I'm very willing to answer questions about issues and my prior writings relating to Israel-Palestine. I would, though, like a direction from the Chief Justice if this is appropriate for me to do so. I am aware that the former Chief Justice was disciplined by the Judicial Conduct Committee for expressing views relating to the Israeli-Palestinian conflict. And I am currently a sitting judge of the Constitutional Court, and I've taken the view, ever since I knew I was an acting judge, I have expressed no view on any conflict that involves foreign policy, that involves the domain of the executive, and I've tried to conduct myself in that way. I am very happy to defend what I said and what my views are, but I'm also not sure that I'm entitled to do.
This is the last third question, Chair. This is true. It's us that were taking long. This is a third
I want to
question. It's
make a
short.
follow-up. I want to make a follow-up on the question before you go to the third one.
The one that is uncomfortable to answer,
Yeah.
and then he will say if he's uncomfortable with your one too.
No, I'm just saying the question is based on the article he wrote.
Yeah.
And we're saying to him, we're putting it to him, that it will be our interpretation that you are saying Israel is not an colonial occupier. And if he says, I'm not going to comment on that, that remains our opinion and it will be raised in deliberations.
Well, maybe what we should do is excuse the candidate briefly and let's talk among ourselves. Is it fine? Let's just do that before we proceed. The candidate, I think I must give you a chance to ask your question.
No, Chief Justice, I was not asking a question. I was just repeating what Commissioner Nonchesi said, and he said it's uncomfortable responding to that. So I was saying to him,
yes,
if that is the stance, it means in the deliberations, I will be allowed to express that view as a correct view because you didn't put a counter argument or seek to clarify it.
Yes. Thanks. No, thank you, Commissioner Malema.
To find a way that the people of that area can share the land and share a future together. That's what I've sought to do. I've tried to be a peace builder in my work. I've tried to engage with peace in Colombia, which is a place which...
Sorry, Prof, you have answered my question.
Thank you.
Procedure, I should end here.
Sorry, Commissioner Nonchesi.
I think in view of time, I must stop here. Other commissioner will follow. Thank you.
Just a follow-up, CJ.
Okay, thank you.
CJ, follow-up.
Oh, Commissioner Malema?
Yeah, mine is very simple, Prof. Do you still stand by that article?
Mr. Malema, I'm not sure I would write every single phrase in the way I did. I shift my own views as well. But in large part, the necessity to find a way through, to understand the two very divergent and competing narratives, and to find a way for the two peoples to listen to each other and to live together in peace and dignity with respect for self-determination and international law, those are all things I would still stand by.
Prof, do you still stand by that article? Because it can't be, you can't have it both. It's either you say there are parts of the article that, given the new information exposed to me, I will rather not keep in that article. So if you stand by it, just say so. So when I leave here, I know Prof still stands by that, or there are these other parts which, with more information and hindsight, is no longer standing with those.
Commissioner, I
opinions.
stand by the thrust of the article, as I've said to you. I think there are changed. We have seen differences over the last 5 years. We have also seen there are currently, and it's not right for me to express an opinion about proceedings before the International Court of Justice at the moment on a number of questions. And as I said, as someone deeply committed to international law, I would also see myself as bound to shift my views if the International Court of Justice finds in certain ways that require me to shift my view. But as I say, I'm not able to express my view on those things. That's inappropriate for a judge sitting in the Constitutional Court at the moment to express views on proceedings currently in an international court, and those may have caused some change to some elements of the article. But the thrust for need for finding a way through to peace, I stand by.
Sorry, Chief Justice. Sorry to interrupt, but you know, Professor Julius, when I first raised my hand 3 hands ago, I wanted to ask you a question about contract, but I'm now going to ask you a question about this thing that's being debated. The reason is because, you know, I always watch candidates here before the JSC. They are asked a relatively inane, mundane question. They complicate their lives, you know, by appearing to be defensive or evasive, etc. Now, I'm afraid that is the impression I'm getting around this issue. And, you know, and it's not a complicated question. You wrote an article and you said you don't buy the story of apartheid, you don't buy the story of colonialism, right? That's fine. We can have debates about that, and apartheid is an international legal issue. And occupation is also an international legal issue. We do need the views of our top judges in the Constitutional Court on these questions, because South Africa is engaged in the international space, and it has been engaged since 1994. It can't avoid it. So this idea that, you know, you say, well, there are certain things have moved along, it gives the impression that you are evading the issue. You know, so
Commissioner, I think that's really unfair. There is currently, as you know and you have argued, there's a case currently before the international...
Hang on, Prof. Hang on. When Commissioner Toby says this to you, to say what you are, the way you are responding gives the impression that you are avoiding. It's to your benefit, because he wants to give you a chance to say to him, no, I'm not avoiding, and here is why you shouldn't think I'm avoiding. You persuade him. So he's giving you that benefit. If you don't explain that, he's going to go into deliberations with the picture that you are avoiding. So he's trying to make sure that he's fair to you.
Thank you, Chief Justice, and I apologize if I appear evasive. I do not want to be evasive in any way. I do not see it, and I take that view as appropriate for me to express a view on proceedings. There's currently proceedings relating, which South Africa has brought, relating to genocide before the International Commission of Justice, and there's also an advisory opinion that has been requested on questions around occupation and apartheid. I see it as inappropriate for me to answer questions about whether or not this is correct when South Africa has a live case and live interest in that, and the principles are being discussed at that level. As an academic, I would love to do that. I'm not currently just before you as an academic. I'm before you as a candidate for the Constitutional Court and acting as well on the Constitutional Court. And so...
No, Professor Pilches, I'm sorry. I think that the problem that I'm grappling with, you know, you were not here when we had a break, but Commissioner Malema made an example and said, if you just asked JP Mlambo, what do you think about Israel versus Palestine? Without anything, you know, he would be entitled to say, I've not actually formulated views. In fact, I'm very surprised that you're asking me that question. Can I please get a pass? But he was saying, what is different with you is that you have, in fact, written an article, right? And you have expressed these views. And so many things have happened. And we just want to get a sense that, all right, this is the view you expressed, this is the view that you take. And that's the only context in which I said, should I not be worried that you are evasive? Because this is not something that you are being asked for the first time. You have written about it. So is this the view now that you carry with you in the Constitutional Court as a future judge? You know? And these things are actually very simple. No one is trying to catch you. In fact, personally, I'm actually I was looking forward to this interview. And I thought this question could be dealt with within a minute.
Well, I'm not sure how I can deal with the question in a minute, but Commissioner, as I've said, I'm not trying to be evasive. I've made perspectives in the past. I have expressed where I stand in the past on these things. At the moment, since I was appointed as an acting judge, I have not commented on the last 6 months of horrific events that have taken place in the Middle East, and I've said nothing for exactly the reason that I believe it would be inappropriate for me to wade into that territory, and that that people in South Africa with vastly different points of view should be able to have confidence in me, and that I will fairly, and I think the key thing that needs to be understood is my commitment to fundamental rights. I've defended that in everything I've done, peaceful resolutions of intractable conflicts.
Thank you very much. Commissioner Malema.
Thank you, CJ. Just a quick one, Prof. So I think we are in agreement that you don't have experience as a judge. For the record, Prof.
That's correct. I have only been acting as a judge for the last few months.
So now,
yes.
if I'm presented with a black African male who comes with a huge experience of a judge, including good judgment writing, and Shemis, at your level, it's you, except that you don't have experience, but also this judge, because I don't buy this thing that only academics can write very well. So for you to be a good writer of judgment, you must be an academic. We've been having very good judges writing very good judgments, and they are not academics. So then through the judgments of this judge, you can see that it's very good. So when you are confronted with that kind of a situation, what do you do?
Thank you, Commissioner Malema. The key,
in line with transformation, yes.
Yes, absolutely. The key provision is Section 1742 of the Constitution, as I'm sure you're aware, which says the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered. In light of our history in South Africa, it is an imperative to have racial and gender transformation. And so I would think there would be a degree of preference towards the black male candidate, or black female candidate even higher in many ways. What I can offer is, as I've mentioned, a diversity of perspectives, and also perhaps one element of diversity that hasn't really been canvassed thus far. And that is that when I was growing up, people with my sexual orientation were criminalized for having same-sex relationships. And during my lifetime, the Constitution has fundamentally changed my life and that of others in the LGBTQ community, first by decriminalizing our sexuality, and then recognizing our rights to stand shoulder to shoulder with other South Africans in dignity. There are still very few openly LGBTQ judges in South Africa, and in fact around the world. And I remember how deeply moving for me it was to see the first Constitutional Court judge, Justice Cameron, appointed to the court. Why is it so important? Because I think when we look at Section 1742, we want South Africans to see themselves in the court. And so I would hope that my appointment would in some sense advance LGBTQ representation, and also perhaps serve as an indicator to the young lesbian woman I met last year from Katlehong, and the transgender activist who I met who was rejected by their religious community, whose families have refused to accept them and for whom they've been rejected, and who opened up to me about their own pain, that the South African legal and political community seeks to embrace people with diverse sexual orientations, and that she and they and others like them, whoever they are and wish to be, can be authentic in their own identities. And so I would suggest to you that there may be other elements of identity, such as sexual orientation, such as disability, which may play a role in the deliberations of this commission.
Last one, CJ. I'm a very, supporter of LGBTQ community. I'm the only president of a political party who marched to Uganda wearing a rainbow flag, because that is a community that I feel very strong. It needs to be supported. You have all what it takes, Prof, except this fundamental issue of experience. And you just joined a church. And then after joining the church, the next thing you're asking is, where are the pastors sitting? Just on arrival. Don't you think that is unheard of?
Commissioner Malema, you point out, of course, my lack of judicial experience, but I am an experienced professor. I am still young, like yourself as a political leader, and I think we're a young country in many ways. We also have a young Minister of Justice and many young people who committed to advancing this country in the different ways that we have to do that. I agree with you. I lack that experience, but I have a different experience, as I've suggested, which is what I need to be considered on the basis of. So it's not something that I can say to you, I can manufacture judicial experience that I don't have. That's something I don't have, but I do have all these other things. And if you think the things that I have can enhance the Constitutional Court, then that's the way in which I put myself forward for the court on the basis of what I do have. Thank you.
I'm very sorry to do this, CJ, too, but why can't you? Because
maybe Commissioner Malema, because I wanted to say something about the question you put to him. If I can just say something before you continue.
But maybe before you say that, so that you can enrich what I'm going to say.
Okay.
Why can't you just say, okay, this is my weakness. Let me go and work on it. And we ask Chief Justice, I don't know who else, the powers that be, to give you more acting stints. And you just said you are young. There are people who self-disrupt. Don't self-disrupt. You are young. There's nothing against you except this element which is workable. You go and work on it, and then you perfect it, and then come back here. And you your interview is going to last for less than 30 minutes when you come back, because we've asked you everything. But you say, if this is a fair criticism, I accept. Let me go and accumulate more judicial experience. Thanks.
Commissioner Malema, that is one possible route, and of course, that is one possible way that my career could unfold. My caution about that route is what it does is it requires, in a way, it says to academics, your only route to the judiciary is in a way by shifting your career from academia into the judiciary. And in a way, already my university is required to find replacements for me and has been very, very kind, the University of Johannesburg, and always very supportive. But what it does mean is that the academic loses their academic dimension and becomes more of a judicial figure, and then only can get appointed. And I think part of what I've suggested is that if you want that fresh academic perspective, in a sense, partly outside the judiciary, then it's possible that it's not a weakness that one doesn't have judicial experience. One just brings something different to the experience of being a judge. Thank you.
Well, I wanted to say, Commissioner Malema and Professor Vilches, that Professor Vilches chose not to say to Commissioner Malema, you see, Commissioner Malema, I was at the university going on with my business, never thinking about acting in the Constitutional Court until the Chief Justice phoned me. and when he phoned me, he said, the only people you would give an acting appointment if they were academics and senior practitioners would be people who would commit themselves to making themselves available. That's why I'm here, So I just want to say, in part, it's the Chief Justice who has encouraged them to make themselves come forward, make themselves available. Of course, that doesn't necessarily mean that they, if necessary, further acting stints can't be given. But I'm just saying the context is that they were minding their own business until the Chief Justice.
Commissioner Malema, your hand was up at some stage, and all the questions you put to the candidates were follow-up questions. Do you still want to?
I've got my questions.
Okay, go ahead.
Thank you, CJ, and thank you for adjusting the aircon because it was horrible the whole day. And it was like the power relations are not properly balanced because the aircon can communicate something else as to who is in charge. I just want to ask, so I can make a quick follow-up on the same. You said you don't remember, no, let me ask it differently. How many judgments did you write since acting in KZN and Eastern Cape? And the CJ said, not exact number, just an estimate, a rough estimate.
A rough estimate could be 15 somewhere.
15.
Yes, 15.
So when the CJ asked you, you said you don't, well, you've written so many, then there, you don't remember how many judgments you have written. You don't remember where you were a leading counsel. You don't remember that.
I do.
Where a judgment was made, not the appeal. The case is settled, is done. You were a leading counsel. You said to Commissioner Nonches that you don't remember which one.
If Commissioner Malema would talk about the reported ones, I do not.
No, not reported.
Oh.
Where you were a lead counsel. That's what he said. He kept on saying that. Where you were a lead counsel, where a judgment has been passed, whether reportable or not. Okay. You said you don't remember that.
I may remember. I may remember, Honorable Malema, some cases where I lead and judgments were delivered.
You remember? No?
Yes, I may remember.
Where you were a senior counsel?
Yes.
There was no lead counsel?
No.
Please take us through maybe one or two. Because you said you remember now. Earlier on you said you don't remember.
No, I was thinking about the reported ones. So I'm talking about now the unreported ones where I lead.
Any judgment where you were a lead counsel?
I have led in matter of land affairs where there's invasion next to Umtata at Mandela Park about land invasions. I led the late Nancy in those matters, a series of them. I also led Matodi Advocate Matodi in a matter of municipality. That judgment, we were dismissed. We were for the plaintiff. We were for the applicant. I beg your pardon, my lord. I remember leading Mr. Healy in a matter for health. I remember leading Lady Advocate Ngalo in a matter can't remember whether transport or education.
That's fine. SC, I've got a limited time. Now, equally, you don't remember how judgments get reported. I'm going to a different point. That's what you said earlier on. You said, I don't know how judgments get reported. I just see them, some written reportable. you don't know how a judgment gets reported for it to become a reported judgment. You don't know that.
I don't know that.
You don't know that, SC.
I say, I confirm.
You said to Chief Justice, you said you are a member of the ANC and you don't know anything against that. And if there is anything of that sort, that will be against your philosophy as a judge. You remember that?
I don't get your question clearly, Honorable.
You remember you said, if you are a member of the ANC and you don't know of any rule that makes you not to be a member of the ANC, and if there is such, it will be against, I'm not quoting you straight, but it will be against your principle or philosophy because that's who you are, a member of the ANC. And you can't wake up one day you are told you are not a member of that organization. That's what I understood you to be saying to Chief Justice earlier on. I can't remember what she said at the end, but your answer was that you are a member of the ANC and that's who you are.
Honorable Malema, you must have not understood me. I said I don't know of any rule that says that prohibits me from being a member of any political organization for that matter. But now I am told, straight away I will relinquish that.
You were told by who?
The judge, the Chief Justice said a judge cannot be a member of a political
Thank you.
party. Yes.
That's where I want the judge, an aspirant judge. Then the aspirant judge also never took any opportunity that presented itself after 1995 to undergo judgment writing and come here, present himself as an aspirant judge and says, well, the last one which I could attend, I missed it and therefore I never took any training, even when there are so many opportunities that came about our democracy where even the young ones are now learning how to write judgment. So all I'm saying, and that's the point I'm going to make when we go into deliberations, and I don't want to be unfair to you. You come across as being complacent, maybe because of your high decorations or whatever the reason might be, that you did not try anything in preparation of this. To a point, you don't remember your judgments, you don't know how judgments get reported, you don't remember, even when given opportunity now, you still struggle to tell us which judgments were you leading, and then you say you don't see anything wrong. Now the Chief Justice tells me, an aspirant judge who prepares for this hearing, where such matters have been canvassed, including on political party affiliation. You say, well, I don't know anything of that sort. And you are not just an ordinary person. Senior counsel, who's an acting judge, says, well, I didn't know, but now I know the CJ told me. I'm going to argue that you are not suitable to be a judge. And worse, with that comments which were made on your judgment writing. Will I be fair that I must live here with my rightful conscience that we have appointed a person who said, I don't know that there is anything wrong with being a member of the ANC, even when you are a judge. But since the Chief Justice said so, I'll relinquish it with immediate effect. It is not in your consciousness. It is not in your conscience that a judge cannot belong to a political party. If we did not have a Chief Justice with a wisdom, judicial wisdom, and just leaves you like that, you are going to continue to be a member of a political party because your conscience doesn't tell you that there is anything wrong with it. Only the Chief Justice told you that.
Just, Honorable Malema, you will be unfair to live with that impression. I'm not complacent. I come here to apply for consideration, but everyone is entitled to make his observation about me. Being a senior counsel, I suppose, does not necessarily mean I should know all. This is my first encounter to come in this in any interview in my life. So my missteps or shortcomings I should be penalized for them, but one should also take cognizance of the fact that this is my first encounter in life that I come into the interview. Insofar as question of being a member of a political party, conscience tells me when somebody says, this is not right at this stage. Surely, consciously I say, I am out of it. For instance, for me to dispense justice, I know I don't have to have any affiliations. This is why I have been chasing and litigating for destitute women and school learners against the government in the Eastern Cape. I have not for once been in a position to say I'm to be biased in favor of the ANC government. I have enforced people's rights against an ANC-led government of the Eastern Cape. This is what I do with pride for the people of South Africa.
Chief Justice, all I'm saying, I'm not saying you must know everything. I'm saying you don't remember where you were a lead counsel. You don't have, that is not supposed to be in law books or in any way. It's you, because you pride yourself as lawyers and judges with your judgments and cases that you lead and win or lose. You know, this is my case. You don't know how a judgments get reported. You don't have anything to show that you attended any course on judgment writing, and that's what's going to be 80% of your work. You have to write judgments. You don't know that. You don't know that you don't have to belong to a political party, which means I must live here. Having recommended the appointment of a member of a political, I'm not saying whether you ruled against ANC or not. I'm talking about the membership. That if we live here today we've appointed an ANC member to become a judge, and where judiciary is accused of being captured. Aspirant judges who come here, they will tell you, I've been a member of the ANC and I resigned since a year ago or 2 years because they knew now I must start cleansing myself of these things, and that's being aspirant. So being aspirant judge means you'll also research what are the common questions there and all of that. All of that, you did not take an effort. You don't know how many judgments you have written. And when I ask you, say, I won't know everything. I'm not asking everything. I'm asking about a rough estimate. Not even me, the Chief Justice does that. That answer doesn't come out convincingly. I'm saying, and this is what I'm going to say, even with your response, I'm not convinced. And I take it, what you are saying is your first experience, first time, and all of that. I'm not convinced you are ready to take the bench. I think, in all fairness, it will be even fair to yourself to give yourself sufficient time. They can give you acting stint, and then you give yourself time to also attend aspirant judges courses to improve on this knowledge and to prepare even much better in the next meeting. Because, I mean, for the next interview or whatever happens in the future, a person who's known by CJ, they've gone to school together, the CJ makes such a disclosure before us. And then in the response, we hear such a complacent person. Even when the CJ said, no, well, I'm going to act fairly, I don't have a problem, but we know each other. Perhaps that might have been something that misled you, that you know her and therefore things are going to happen. They are not going to happen here. Here you come prepared. Thank you very much.
Is somebody who wishes to put some question to the candidate?
Julius.
Commissioner Malema.
Thank you, CJ. Judge, is it an acceptable thing that, maybe let me put it differently, that we have observed a huge temptation to capture the judiciary, especially from the executive and politicians who want to use their judiciary to fight their political battles. And all of us without fail have gone all out to protect the judiciary against politicians who want to capture it. Will it be an acceptable thing that some NGOs here must capture judiciary to serve their own interests because they are not political parties? Is it acceptable that if it's not political parties, it's okay that these NGOs must capture the judiciary?
Commissioner, I think the position is very clear, which is that it's critical that the judiciary should be independent and beholden to no one but their oath of office and to the Constitution, and they should be captured neither by politicians nor by NGOs, but simply do their duty as independent judges.
Now, my second question, Judge, is, does experience count for anything for you? Like, do you think it's necessary for people to get an experience before they assume certain responsibilities permanently? And let me take it further that, do you still hold the same views you were holding before you acted in the Constitutional Court? Or you think that your acting actually helps somehow to put you in a better and a different position?
I think experience is always helpful. I think we have had examples of very, very good judges who have had little or no experience and discharged their judicial functions with great distinction. But it is always helpful to have experience, and I'm particularly grateful that I have had 2 years on the Supreme Court of Appeal and have now had the opportunity to act in the Constitutional Court. I don't think, in other words, that you can never have an appointment without the requisite experience, but I think that it is helpful, and it has been helpful.
And will you agree with me, Judge, that acting and acquiring an experience is so helpful that it will even empower you to a point where you don't make minor mistakes, especially at that level of the Constitutional Court, because that is the highest court where you cannot afford to make minor mistakes. And part of the things that would make you not to make minor mistakes, it is acquiring an experience.
Well, Councillor, I'd say this, that I'm afraid human error is part of everyone's experience, and no matter how long one pursues a particular career or a particular line of engagement, you can always make a mistake. We're all fallible, we're all human, I am, and we can make mistakes, and we have to acknowledge that, and it's true of everybody. And if I've made a mistake, it's not because I believe I lack experience, it's because everyone can do so from time to time.
Judge, I agree with you, we are all going to make mistakes, but that is not my question. My question is, acquiring experience, especially when you go to the Constitutional Court, helps you not to make minor mistakes. Underline minor mistakes.
Yes.
There are certain things are ABCs of the Constitutional Court. And if such minor mistakes are committed at the Constitutional Court, you'll destroy the image of that court. And once you destroy the image of that court, you destroy the confidence of our people on that court. And once our people no longer have confidence into that court, it will lead into the state of anarchy. So I'm saying, do you accept that experience will help you not to commit minor mistakes, not mistakes, minor mistakes?
I don't accept your proposition. I don't think that the kind of experience one gains, important as it is, ever prevents a minor mistake from being made. These things happen from time to time, and if they do, they're regrettable, but I also don't accept that because what you've said is a minor mistake, if it has been made, somehow that leads ordinary people to suddenly lack confidence in the Constitutional Court or the judiciary at large. People recognize, as they do in every walk of life, that people make errors, and as long as those errors are corrected and acknowledged, then there is no threat whatsoever to the institutional integrity of the courts or any other part of our constitutional structure.
You know, it is minor mistakes that ordinary people will appreciate. Those legal jargons and whatever arguments you make there, we may not be able to pick them up. But once you start engaging in minor mistakes, then that court is going to be flooded with rescission applications, and it will be forced to change its own decisions. And once it starts changing its own decisions, it suffers image crisis and confidence crisis, and that leads to our people losing confidence in that court. Will you agree with me?
Councillor Malema, I can't agree with you. Rescission is a very particular kind of procedure, and it has been resorted to more often of late. But there are very few instances in which courts make errors, but if they do, they can be corrected, and they should be corrected, and I don't believe that it leads to this wholesale lack of confidence that you suggest.
My last question is, does seniority count for anything for you? I don't know anything about law, and I'm not a lawyer, but every time I go out with lawyers, CJ, and then we go to a dinner or something, they say the senior counsel must pay because he's the most senior person there. and that they always accord respect to that senior because of that seniority. Then there will be judges. I heard JP saying earlier on, he thought he was the most senior in the room and all of that. So you've got this tradition amongst judges and by extension, lawyers, and by extension, judges who respect seniority. And it's not only in the legal fraternity or in the judiciary, it's also in the church, where you can't join judge. Today you get baptized. The following day you ask the question, where are the pastors sitting? After being baptized, you give yourself some time to familiarize yourself with the processes there and allow the seniors to take you through and teach you. So my question is, does it really, seniority, does it matter to you? Because I'll tell you why I'm asking you this question, Judge. I respect you very highly, and those who are in my legal battles respect you very highly. Some of them nominated you. But I've got a problem that and you can see that we consider you very highly. We appointed you and you are being given opportunities to act and all manner of things. But you are in this hurry to a point where you even want to pass the people you found in the judiciary and go and lead them at the Constitutional Court. Why can't you give yourself time? You are now acting. Earlier on when we interviewed you and told you about acting, you had a different view. Now you are acting. Can't you give it some time to continue acting and accumulate the necessary experience? Then this argument of seniority and minor mistakes and experience will fall off, and you assume that position properly without anyone having questions. Seniority, does it matter really to you?
Yes, Councillor, I don't think we value seniority just for the fact of seniority. We value seniority because it sometimes represents cumulative knowledge and experience that can be usefully brought to bear. And that's sometimes valuable, and we take account of it for the reason of its substance, not simply because it is a rank that has been attained through the passage of time. I think in my case, it's a question of how the Commission and yourself assesses the fact that I have had a very lengthy career at the bar, in which I have done a great deal of constitutional work over a very long period of time. I have had experience across many areas of law, and I have acted in a judicial capacity in the WTO for some 8 years. And it's now a question of whether there has been enough further experience within the South African judiciary that would suggest that I can make a contribution. I believe that I can, and I'm happy to further explain what that contribution would be. But if it is the case that you or the Commission at large takes the view that it is only sitting judges who have sat for 10 or more years, well, then you will announce that policy and people will know where they stand. And speaking for my position, I will then become too old to ever assume a position on Constitutional Court, and I will not be able to make that contribution. But that's a judgment ultimately for the Commission to make. It's not one that I can. I believe I have cumulative experience of some value to a contribution I can make at the Constitutional Court, and if I'm given the opportunity, I should love to do so. But if that isn't the requisite combination of experience that counts for the purposes of appointment, well, then I will accept that, and that is how things will be.
Thank you, CJ. Thank you very much, DCJ. Judge, you have dealt with a number of issues pertaining to the children and all of that. If you look at the situation of GBV here in South Africa, it's like a war has been declared against women. It's like we are in a war zone if you're to look at stats and compare it with areas where there is war, rape, women and children abuse.
Yes.
Do you think we are handling it correctly as a country, or do we need dedicated special courts that will deal with issues of GBV speedily and make sure that perpetrators are brought to book and convicted and sentenced to a very long time in prison, so that people can see that indeed the law is beginning to bite on issues related to GBV, rape, and women and child abuse?
Good morning, Commissioner Malema. I think we have a serious problem on gender-based violence. The social context training that I was talking about, that I say in our training material at Justice College, we were trying to introduce, to say to people, to judicial officers, this is a new era. In that we said to judicial officers, we come from a very violent history as a country, as a people, and this has permeated into this new democracy that we have. We say in social context, in the corporate world, and I think private practice and academia, they call it diversity training, smart, fancy word. And we say in there, we say to judicial officers, you must acknowledge what you are doing, that you too may be a perpetrator, that you too may be a victim of gender-based violence without even appreciating it. But we bring in specialists from outside, psychologists, and all that different disciplines that would say to us, if I know I come from a home that is like this, I should be able to say this is gender-based violence. In that way, Commissioner Malema, if we appreciate that we can also be perpetrators, we can also be victims, and be honest about it, we will deal with it for what it is. We will be strong on it. We will, to the point where you say, I know what you are doing. I know I have seen this. I know what, therefore, I'm not going to allow it. I will give you an example. When we trained clerks of the court in the magistrate court on domestic violence, for instance, we say to them at Justice College, you are not the decision maker when a woman comes to you on a Friday saying, I have been assaulted, to say, I am not, you come on Monday, because you don't know if this woman will be alive by Monday. Your responsibility is to treat it as urgent, take it to the magistrate. It's the magistrate that will decide, and probably the magistrate will issue a warrant of arrest held in abeyance for the weekend, so that if this person assaults you again, at least this woman has this weapon, can go to the police, the person can be arrested. So we need to infuse those kind of practical ways of dealing with this, because we come from that background. We know what we're talking about. It's just implementing. If we look at gender-based violence, DCJ, allow me to deviate, to divert a little bit, because Commissioner Malema is touching on a not that it's other issues are not important, but it's a very sensitive issue that we have to address.
Well, South Africans have to talk about gender-based violence always.
Thank you, DCJ. I am now doing research for the past 4 years, looking at gender-based violence at universities. I am asking the question to young people, focusing on UCT roads where that flared up. I'm looking at Limpopo at the University of Zululand, where I come from. And I've asked in that article that's still going on, why is it happening under your watch? How does rape happen on a university campus that is supposed to be teaching you to be better? How are you going to be future leaders when you are raping, when you are doing this to young? How do you not protect women, young women that are there? You know, so we look at those things. We need to be doing more work. I say to students, you can't be toying all the time. You can't be doing what NGOs are doing. You have to challenge the legislature and say, these laws are not tight. This is how we want them tighter. The students, you can't have a doctorate, a master's on something happening in European countries, when what is happening in your own country, you are not addressing. I say that much. Coming back to what more can we do, I think as much as we try to hold everything as tight as we can as judicial officers, we have that balance, Commissioner Malema. The Bill of Rights that says this person also has rights. We balance that with that of the victims, and we say, where can we meet each other here, but give a sentence that society will appreciate, that we're not breaking this person totally. We're saying a first offender that requires, that also needs to be rehabilitated, that comes from a broken home, a broken background. What can we put in place to rehabilitate this person to be a better person? When you have a young person of 32 years married, but already assaulting his wife, you ask yourself, what is wrong with this one? He's from a university, has everything for him, but he assaults and does any other thing that falls under gender-based violence. Then we have to say, but we can't have this situation. But we look at everything and then say, in this instance, this one deserves a bit of rehabilitation. Can we improve on him, and this and this and this? We look at the victim as well to say, how can we ameliorate the situation at home? We bring in other role players for them to contribute to whatever sentence that we will be imposing. I think we need to put in a lot of restorative justice, where people can sit and talk about these things before they even go that far. We don't use it a lot. I said it at one conference under the United Nations of UNODC, where we were talking about the responsibility of judicial officers to address gender gender-based violence for what it is. We need to be stern about it, send out the correct message, but in the process, also appreciate that our Constitution puts this responsibility on us to bring it. But not only the Constitution, Botho, Bore, what could have gone wrong with this young man? Let's look at that and address it for what it is. In short, I hope that's short enough, Commissioner Malema.
No, it's not short enough. You have not answered my question.
Really?
I'm asking this in the context that you are applying for the electoral court position. So
Okay.
there's a special court for elections because these powermongers may feel that they've been robbed and therefore they can even fight to a point where there is a war. Elections have got a potential to cause a civil war in a country. That's why there must be a speedily process to resolve them so that you avoid potential war.
Okay.
That's why there is a special court for electoral issues. So I'm saying there's no war on elections, but already there's an electoral court.
Okay.
But there's a war on women. When we wake up, we don't ask if there was a woman raped. We ask how many were they raped. That's how abnormal we have become as a society. We have become a sick society. How many have been killed, not whether a woman has been killed or not. A war has been declared already.
Yeah.
Have we not reached a point where we think a special court must be established to deal with these matters in a manner that will give confidence to society and send a strong message to the perpetrators that the country now has moved from talking into action and that these matters of gender-based violence and rape and women and children abuse are now a priority to our country? Because
I hear you.
when you travel the world, you will know better than me. In the past, when you said you're from South Africa, they will say Mandela. Today, when you say from South Africa, they talk rape, they talk women abuse. What do we do? Is it not time that we establish a special court to deal with rape, GBV, domestic violence, and related matters, so that these matters do not last forever, to a point where a woman is being persuaded, because the longer they take, the more family interventions come in to say, no, these are family problems, withdraw the case, let's find one another. But by the time they want to arrive at family issues, and then the Tsotsi is in prison already. We've dealt with the issue, we've finished it, we've imprisoned the perpetrator.
I hear you. Minister Lamola, the South African Law Review Commission had submitted to the former Minister Penuel Maduna recommendations that South Africa needed a one family court system that deals with these issues speedily, where there are experts. I think many professors, particularly from UCT, Professor Sloth Nielsen, that's a specialist in family law, child Hague Conventions matters, sat on that task team. And special courts were set up in the cities, the Johannesburg, Durban, and what is it? What's the other one? Johannesburg, Durban, and Eastern Cape, I think, if I'm not mistaken. I'm subject to correction. But there were courts that were put in place. We don't know where the political will changed, but then those courts are no longer operating. Minister Lamola opened a court in Durban that is beautiful. It has everything that you would wish to see in all parts of South Africa. You find specialist magistrates there that deal with domestic violence, maintenance, all family law related matters, which would automatically include gender-based violence, I agree with you totally that there should be that kind of move, and we should say so openly. But it is also it lies with the Department of Justice and role play and other stakeholders. But as I say, Minister Lamola did that in Durban. Surely that can be done in other parts of the country.
Thank you very much, DCJ.